Hello, welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we are going to cover news dated 10 September 2018, the news which has been presented on the screen. Timestamping for the same has been provided in the description box below. Let's start our today's discussion. The first news appears on page number 1 and also appears as a continuation on page number 10. The news reads, Tamil Nadu recommends release of all 7 Rajiv case convicts. Governor bound to accept cabinet decision under Article 161. Now this news is with respect to the clemency power of the governor as provided in Article 161 of the Indian Constitution. This particular news pertains to GS paper 2 specifically under functions and responsibilities of the union and the states and also functioning of the state legislature. So in this news, the Chief Minister of Tamil Nadu has recommended to the governor that all 7 convicts in the assassination case of former Prime Minister Rajiv Gandhi to be released under Article 161 of the Indian Constitution. So in this particular news, from an exam point of view, let us understand the clemency power of the governor as provided under Article 161 and also of the president under Article 72 of the Indian Constitution, as question have been asked previously in the year 2014 based on the clemency power of the president. So in this aspect, let us first understand about Article 161 of the Indian Constitution. Now, Article 161 of the Indian Constitution says that the governor of a state shall have the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence against any law relating to a matter which the executive power of the state extends. And by the meaning of the word executive power of the state extends, it means that to the matters with respect to which the legislature of a state has power to make laws under state list as well as concurrent list. So on any matter under which the state power extends, the governor has the right to grant pardon, reprieves, respite, remission of sentence, or even to suspend, remit, or commute the sentence. In this aspect, let's understand these different words. A pardon impacts both the punishment as well as the nature of offence, and a full pardon may blot out the entire guilt itself. Further, reprieve means a temporary suspension of the punishment awarded by any court. Respite refers to postponement of the sentence of punishment, and commutation here refers to changing the punishment from one category to another category, such as changing of a death sentence to a life imprisonment. And remission refers to the reduction of amount of a sentence without changing its character. So in this aspect, even the news mentions about the possible grounds of remission, where it says change in circumstances as the convicts have completed 27 years in prison. This news further talks about 4 points with respect to Article 161 of the Indian Constitution. It says that the advice of Council of Ministers is binding on the governor, so he may accept it immediately. So this becomes an important fact with respect to Article 161. Further, no time limit is prescribed in the Constitution and the governor can take his own time. Now this again becomes very important as there have cases of presidential delay or delay by the governor with respect to clemency powers. Further, the governor can seek centre's opinion in the matter. This again becomes another interesting point, as in such controversial cases, at times the governor tends to take centre's opinion. And further it says the governor can seek reconsideration of the decision by the Council of Ministers. So all these points becomes extremely important. Now with respect to this, let's see a question asked in the year 2014 under GS paper 2. The question read, instance of President's delay in commuting death sentences has come under public debate as denial of justice. Should there be a time limit specified for the President to accept or reject such petitions? Analyze. So this question was asked with respect to delay in commuting death sentence as well as that resulting in denial of justice. So for that, let's understand certain key points as well with respect to the President's power of clemency under Article 72 of the Indian Constitution. As per Article 72 of the Indian Constitution, the President shall have power to grant pardons, reprieves, respites, or remission of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence. However, in this case, there are 3 important facts which must be understood with respect to clemency power of the President. It says that this applies to all cases where the punishment or sentence is by a court-martial. Further, in all cases where the punishment or sentence is for an offense against any law relating to a matter to which the executive power of the union extends, and further in all cases where the sentence is a sentence of death. So the president has much wider power with respect to clemency as compared to that of a governor. Here it says the governor does not have any power with respect to cases under court martial. So this must be remembered, as this is an important point of difference between the clemency power of the governor as that of the president. So president enjoys a clemency power under court martial, whereas governor does not enjoy that particular power. Further it says governor cannot pardon death sentence. Now this again becomes an extremely important point to remember. However, the governor can only suspend, remit or commute a death sentence, whereas pardoning power of the president extends even to cases of death penalty. So this is another difference between the clemency power with respect to president and the governor. With respect to pardoning power, only the president has the power to give a complete pardon, whereas the governor can only suspend, remit or commute a death sentence. Now another important point with respect to both the president and the governor is that whether they are bound to follow the aid and advice given by the Council of Ministers. It says that a power vested in the president shall not be exercised independently without the aid and advice of the Home Minister. And in this aspect, in the case of Maruram versus Union of India, the Supreme Court had held that under Article 72, the president cannot take an independent decision or direct release or refuse release on his own choice. Hence, in the aspect of clemency powers, for both the president as well as the governor, they do not enjoy any discretionary power. And this becomes an important aspect to remember with respect to their clemency power. The court had held that a discretion was not given to both president as well as the governor, as decisions could have been made on certain arbitrary grounds or some partial grounds of religion, caste, color or political loyalty. So in this aspect, the decision of the Council of Ministers becomes mandatory on both the president under Article 72 and on the governor under Article 161 with respect to any clemency power provided therein. Another important point in this aspect is judicial review available on such clemency powers of both president and the governor? It says the court can interfere if it finds that the decision has been taken without application of mind or decision has been taken on irrelevant considerations or due to certain mala-fides, that is decision taken in bad faith. And in the case of Epuru Sudhakar versus Government of Andhra Pradesh, the Supreme Court had laid down that judicial review under Article 72 and 161 is available on the following grounds. Let's see those grounds. First, that the order has been passed without any application of mind. Second, that the order is mala-fide or in bad faith. Third, that the order has been passed on extraneous or wholly irrelevant considerations and that the order suffers from any arbitrariness. Further, the court highlights if the decision has been taken by the president and the governor by mistake or in case of fraud, then such decisions can be cancelled by the court. The court further held that if power under Article 72 is exercised on irrational, irrelevant, discriminatory grounds or in bad faith, then also in such cases the Supreme Court can examine whether they can intervene in such cases or not. So the two things which emerge from this discussion is that judicial review is applicable on clemency power given by the president as well as the governor, and they have to follow the advice given by the Council of Ministers. However, no time limit has been prescribed in the constitution. Hence, at times we witness certain cases of delays with respect to decision taken by both president and governor under Article 72 as well as 161. So this particular news as of now seems to be in transition. Let's wait and watch for the final decision of the governor with respect to his power under Article 161. As we have seen, a question has been asked by UPSC in the mains examination. Hence, this topic becomes extremely important for us to understand. With this, let's move on to the next news. The next news appears on page number 8 in the editorial section. It says, bail over jail. The chain of arrest, custody and remand must be linked only by due process. Now this particular editorial is with respect to rights of an accused in case of arrest by the police. This topic under your prelims examination forms a part of rights issue under Indian polity and governance, and in the mains gets covered under GS paper 2. So as mentioned, this editorial is with respect to rights of an accused in case they are arrested by the police. The editorial highlights that the power of arrest given to the police must not be used in an arbitrary manner, which may cause undue harassment to the accused of such crime. In this aspect, the editorial also highlights a Supreme Court judgment where the Supreme Court had held that the arrest of a person should never be a reflexive response to an allegation of an offense, as mere arrest does not prove guilt of the accused in any crime. And such arrest of an individual has to be followed the due process of law as provided under Article 22 of the Indian Constitution. In this aspect, let us also understand certain basic facts about Article 22 of the Indian Constitution, which is also a part of Part 3, that is fundamental right. Now, Article 22 of the Constitution provides for protection against arrest and detention in certain cases. It says that no person who is arrested shall be detained in custody without being informed of the grounds of such arrest. So, whoever is arrested, they must be informed about their grounds of arrest. Further, they also have a right to be consulted or defended by a legal practitioner. Further, Article 22 Clause 2 says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest. So this becomes a crucial aspect with respect to rights of a person who has been arrested by police. An exception is also provided in the Article 22 itself. It says that the above mentioned rule shall not apply to if the person concerned who is arrested is an enemy alien or any person who is arrested or detained under any law provided for preventive detention. That is, if any person is arrested under preventive detention law or if a person is an enemy alien, then in such cases these two provisions shall not apply. Further, in such cases it says that if any person is detained under preventive detention law, they shall also not be detained for any period longer than 3 months. Now here 3 months refer to 180 days. So we can see that if a person is arrested under preventive detention law, then at the max they can be kept in detention for 180 days. And if the period has to be extended beyond 3 months, then the suggestion has to be provided by the advisory board. So all these aspects with respect to preventive detention becomes important as they also impact the rights as well as liberty of a person concerned who is arrested under any preventive detention law. So the article also talks about detention for more than 3 months, where Article 22 Clause 7 provides that the Parliament, by making any law, can prescribe the circumstances where any person can be detained beyond 180 days. And in this aspect, the Parliament may also prescribe the maximum period for which any person can be detained under such preventive detention law. So we understand that Article 22 becomes very important with respect to rights of a citizen in case of any arrest or preventive detention. In case of normal arrest, they have the right to get informed on grounds of arrest, and they also have a right to be consulted or defended by any legal practitioner or a lawyer. However, these two rules shall not apply if the person concerned is an enemy alien and if a person is detained under preventive detention law. And for preventive detention law, a person shall not be detained for more than 180 days. And if the detention has to extend beyond 180 days, then in such case, the suggestion of advisory board has to be taken. Further, if the Parliament may also wants to extend this period of 3 months, that is 180 days, then by law, the Parliament can prescribe for such an event. So this editorial of rights of an accused in case of arrest by the police becomes extremely important for us to understand from a rights perspective and also from the perspective of Article 22 of the Indian Constitution. With this, let's move on to the next news. The next news appears on page number 8 in the editorial section. The editorial reads, "Cloudy forecast. Developed countries, especially the United States, need to commit funds to limit the climate change." Now this topic forms a part of GS paper 3 under your mains examination as well as a part of general issues on environment, ecology, biodiversity and climate change in your prelims examination. Now repeatedly questions on climate change have been asked by UPSC in the previous examinations. We'll go through some of the questions asked by UPSC. First of all, let's understand what this particular editorial talks about with respect to committing funds by the developed country. So the editorial highlights the difficulty in raising funds to help the poor nations in developing technologies to reduce their greenhouse gas emissions. And in this, the reluctance on part of developed nations to commit certain funds for these climate change. So let's understand the highlights of this editorial with respect to this reluctance on part of developed countries in helping the poor nation to reduce their greenhouse gas emissions. Now, the conference of UN Framework Convention on Climate Change was supposed to draft a rule book for the Paris Agreement ahead of the crucial international conference to be held in Poland in December 2018. However, the entire exercise ran into trouble over the issue of raising funds for the poor nation. In this aspect, some of the developed countries led by United States are unwilling to commit to rules on raising funds for climate change for the poor countries. Now, this development is against the Paris Agreement. Now, as per the Paris Agreement, rich countries pledged to raise $100 billion per year by the year 2020. And this money was to help developing countries to reduce their greenhouse gas emissions. And this money was also to be utilized to help the population to cope with extreme events such as floods, droughts, or even storms. Now, in this aspect, unwillingness on part of some of the developed economies to help the poor nation can be said to be a decision without considering its long term impact, as cases of extreme weather events are becoming a regularity. Now, such extreme cases have made countries and people vulnerable to these catastrophes caused by such disasters. These extreme events also have an impact on the economy of the people as well as the countries, as such events disrupt daily economic activities of people. Further, such extreme climatic events also results in a failed agriculture, and this failed agriculture will further lead to mass migration of people towards cities, and this will further impact the sustainable capacity of any city, leading to further issues of disruptions. And this will also impact the ability of a city to provide certain basic necessity such as clean drinking water. Further impact of the climate change are irregular events of catastrophes such as storms, cloudbursts, floods, droughts, and all these have impacted the environment, people, as well as economy of a particular place, which is disrupted through these catastrophes. Further, a 2 degrees Celsius rise will also destabilize the Greenland ice sheet, and we have already noticed certain damage done to the West Antarctic ice sheets. So all these some of the impacts of climate change, and in this aspect it becomes the duty of all the countries including developed, developing and the poor countries to come together to combat such cases of climate change. The editorial further highlights that in this respect both India and China also have additional pressure to reduce greenhouse gas emission, as both India and China as members are committed to the Paris Agreement. Hence, in this aspect, India and China must take the responsibility of climate leadership for the developing world. However, having said that, the developed nations also have to share their part of responsibility, considering larger share of greenhouse gas emissions historically by the developed nations. Thus, in this aspect, both the developing and underdeveloped countries needs a supporting framework or a rule book which bind developed countries in providing finance for climate change, which provides support for capacity building, and which provides for transfer of green technologies on liberal terms. Thus, we understand that this editorial on climate change and commitment of the developed nations to provide fund for the underdeveloped and developing nations for capacity building as well as for transfer of green technologies on liberal terms to reduce the greenhouse gas emissions will further help in combating the impacts of climate change. Now, as mentioned earlier, various questions have been asked by UPSC on this concept of climate change. This particular question was asked in the year 2014. The question read, the scientific view is that the increase in global temperature should not exceed 2 degrees Celsius above pre-industrial level. If the global temperature increases beyond 3 degrees Celsius above the pre-industrial level, what can be the possible impact or impacts on the world? The option provided were terrestrial biosphere tends towards a net carbon source, widespread coral mortality will occur, all the global wetlands will permanently disappear, and cultivation of cereals will not be possible anywhere in the world. Now, statement 3 and 4 are very sweeping statements, that is, all global wetlands will permanently disappear. No, it will not be such a case. Further, cultivation of cereals will not be possible anywhere in the world. No, 3 and 4 are not correct. So, here the correct answer was 1 and 2. Further, 3 questions were asked on climate change in 2016. The question was, with reference to the agreement at UNFCC meeting in Paris in 2015, which of the following statements are correct? First, the agreement was signed by all member countries of the UN and it will go into effect in 2017. No, this statement is incorrect. Further, the agreement aims to limit the greenhouse gas emission so that the rise in average global temperature by the end of this century does not exceed 2 degrees Celsius or even 1.5 degrees Celsius above pre-industrial levels. Yes, we have already seen this, so this is a correct statement. Further, developed countries acknowledge their historical responsibility in global warming and committed to donate $1,000 billion a year from 2020 to help developing countries to cope with climate change. No, this statement is incorrect. As you can see, rich countries pledged to raise $100 billion by 2020 per year, and the option provided for $1,000 billion per year. Hence, both statement 1 and 3 is incorrect. So here the correct option is B, that is 2 only. Further, a question was asked on greenhouse gas protocol. It said, what is greenhouse gas protocol? Here A is our correct answer. That is, it is an international accounting tool for government and business leaders to understand, quantify and manage greenhouse gas emissions. Further, another question was asked on intended nationally determined contributions. Now the question was, the term intended nationally determined contribution is sometimes seen in the news is in the context of pledges made by European countries to rehabilitate refugees from war-affected Middle East? No, this is incorrect. B. Plan of action outlined by the countries of the world to combat climate change. Yes, this is the correct answer with respect to intended nationally determined contribution. Now in this, it says that the Paris Agreement requires all parties to put forward their best efforts through nationally determined contributions and also to strengthen these efforts in years ahead. This includes requirements that all parties report regularly on their emissions and on their implementation efforts. So a question was asked again in the year 2016 on this intended nationally determined contribution. So we see this issue of climate change becomes extremely crucial as number of questions has been asked by UPSC in the previous years. Hence, this editorial cloudy forecast becomes extremely important from an exam perspective. With this, let's move on to the next news. The next news appears on page number 5. The news reads, 2 irrigation facilities in Telangana get heritage tag. Now in this news, in a meeting of the International Executive Council, which is the highest decision-making body of International Commission on Irrigation and Drainage, has accepted Telangana government's nomination of Sadarmat Anikat as well as Pedda Cheruvu. The nomination by the Telangana government of Sadarmat Anikat, which is in Nirmal district, and Pedda Cheruvu, which is in Kamareddy district, have been given the heritage tag by this ICID, that is International Commission on Irrigation and Drainage. Now this particular news forms a part of Indian geography as well as environmental ecology, biodiversity and climate change. Now let's understand few basic points about this International Commission on Irrigation and Drainage, that is ICID. The ICID was established in the year 1950 and this is a leading scientific, technical and international not-for-profit and non-governmental organization. So you must remember that ICID is a not-for-profit and not governmental organization. It further says that ICID is a professional network of experts across the world in the field of irrigation, drainage and flood management. Further, the main mission of this ICID is to promote sustainable agriculture, water management in order to achieve water secure world free of poverty and hunger through sustainable rural development. So this institution becomes extremely important for us to understand from an exam point of view. Now this Sadarmat Anikat is built over the river Godavari and this Pedda Cheruvu is located in Kamareddy district of Telangana as has been already mentioned. So this small news becomes extremely important as questions can be asked on Sadarmat Anikat as well as Pedda Cheruvu since they have been provided heritage tag by this International Commission on Irrigation and Drainage and also the purpose of International Commission on Irrigation and Drainage, that it is a not-for-profit and non-governmental organization and it works in the field of irrigation, drainage and flood management. And its main mission is to promote sustainable agriculture, water management to achieve water secured world free of poverty and hunger through sustainable rural development. So this becomes a key information from our exam perspective. Now another news appears on page number 5 which mentions endangered Pondicherry shark spotted near Kakinada. Now in your prelims examination, this topic also forms a part of the environment section. Now in this particular news, field biologists from the East Godavari riverine estuarine ecosystem, which is also known as EGRI, have spotted this Pondicherry shark. Now in this aspect, let's learn certain basic facts about this Pondicherry shark. It says that Pondicherry shark was once found throughout Indo-Pacific coastal waters from the Gulf of Oman to New Guinea and is known to enter fresh water. Currently, the only known sightings of this species has been since the 1980s, which were in the rivers of Sri Lanka. Another important aspect with respect to Pondicherry shark is that the IUCN, that is International Union for Conservation of Nature, has listed the Pondicherry shark as critically endangered, and locally it is known as Palasora. So here you can see in this map that it forms a part of threatened species under critically endangered. Now question on IUCN was asked in the prelims examination of 2015. The question read, with reference to IUCN and CITES, which of the following statements are correct? IUCN is an organ of the United Nations and CITES is an international agreement between the governments. Further, IUCN runs thousands of field projects around the world to better manage natural environments. Third, CITES is legally binding on the states that have joined it, but this convention does not take place of national laws. Here, statement 2 and 3 are correct. However, statement 1 is incorrect. So the correct answer here was B, that is 2 and 3 only, as IUCN is composed of both government and civil society organizations and it's not a part of United Nations. So we understand that this news on Pondicherry shark becomes important, as you must remember that it has been spotted near Kakinada in Andhra Pradesh and IUCN has listed the Pondicherry shark as critically endangered. And we also saw that a question was asked in the year 2015 on IUCN as well as CITES. So this topic of Pondicherry shark becomes important from our prelims point of view. With this, let's move on to the next news. The next news appears on page number 14. The news reads, why SEBI norms spooked FPIs? AMRI warned of a $75 billion outflow from equity markets. Now this topic forms a part of GS paper 3 under economic development, and in your prelims it forms a part of economic development. Now in this particular news, in the month of April, SEBI had issued a circular on enhancing KYC norms for foreign portfolio investors. Here KYC norms refers to know your customer norms. In this circular had also imposed certain restrictions on the investments made by NRIs, that is non-resident Indians. Now this circular caused a concern with respect to outflow of FPIs from India. So in this, the Asset Managers Roundtable of India also warned of a potential outflow of $75 billion from Indian equity market. In this context, the SEBI had appointed the HR Khan-led committee to ease norms for overseas investors. So in this aspect, let us understand first of all what was the SEBI circular. The circular said that a company which is majority owned by one or more NRI or PIOs, that is person of Indian origin, shall not be allowed to make investment as an FPI. Now this became a cause of concern. It further informed that the NRIs, overseas citizen of India, cannot be beneficial owner of FPIs, and in this aspect the term beneficial owner was explained as the one who controls 25% of company's ownership. So suppose if a NRI or OCI controls 25% share of a company, then they collectively cannot invest as a FPI in India. Further, the circular also barred NRIs from acting as fund managers of FPIs. So first of all, they cannot invest as FPI in India if they collectively own 25% of more in a company, and also they cannot act as a fund manager of FPI. So this led to a belief that this will cause an outflow of FPIs from India. Further, these FPIs were given a time frame of 6 months to change the structure or close their existing position in Indian securities market. And this particular restriction to invest to FPI was imposed on resident Indians, OCIs, that is overseas citizen of India, PIOs, that is person of Indian origin, as well as NRIs, that is non-resident Indians. Now the concern expressed are that FPIs have invested more than 450 billion US dollars in India, and out of which $75 billion is managed by overseas citizen of India, person of Indian origin, as well as NRIs, that is non-resident Indians. And this aspect of circular has led to concerns that it would lead to an outflow of huge amount of FPIs from India. So in this aspect, the HR Khan committee has recently submitted a report. Let's go through what the committee has said. The committee has suggested that NRIs, OCIs and resident Indians should be allowed to manage foreign funds that invest in India subject to certain holding limits. Now, what are these holding limits? The committee suggests that a single NRI or OCI should not hold more than 25% of the assets in FPI. Whereas the aggregate holdings of these NRIs, OCIs, or even resident Indian shall not be more than 50%. So the committee has actually increased the limit from earlier 25% of SEBI circular to that of 50% in case of aggregate holdings or if they invest as a company. And the committee has also suggested that SEBI should release the revised circular based on public consultation with respect to concerns over outflow of FPI money. So this news on FPI and SEBI circular becomes very important for us to understand from prelims point of view. Now in this particular news, the word FPI, that is foreign portfolio investors, refers to investors who invest for short term. And these FPIs participate through stock market and gets in and out of stock market very frequently. So this FPI makes a frequent entry as well as exit from the stock market. Further, FPIs are defined as those institutions who hold less than 10% in a company. So in this news, let's wait and watch whether SEBI accepts the recommendation given by HR Khan committee to increase the aggregate holdings for NRIs, OCIs and resident Indians with respect to FPI investment. With this, we come to an end to discussion of today's newspaper. Let's move on to the question for the day.